All right. Good afternoon, everybody. Welcome to another IMAA webinar. We're excited to have Sue Dulek from the City of Iowa City join us. She's the first assistant city attorney for the City of Iowa City. Very excited to have her. And Iowa City is a special place in our lovely state. I only say that because I'm a native of Iowa City, so I could get away with saying that. Of course, I love all 939 incorporated cities. Everyone here does at the league, but again, Iowa City holds a little special place in my heart. And so, with that, I'm going to turn things over to Sue here shortly. But first, Sue is welcome to take questions throughout the session. We talked before this, and so we would encourage anyone with questions to use either the Q&A function within Zoom or the chat. And if those things don't work, I'm guessing Sue won't mind you unmuting yourself and bumping in with a question as we go. And so that's how we're going to handle it. So again, if you have any questions, just use the chat or the Q&A, and I'll keep my eyes on that. And then just again, kind of butt in on Sue when there's an opportunity to ask those questions because we do want to take them throughout, and so they're timely. Um, and Sue's going to use a handout here, as you can see. We will make that available after that. I'll do a follow-up email to all the registrants for this webinar, include that handout, and I'll also include the CLE activity number just in case you didn't catch that in the first email. Just make sure everybody has it. So with that, Sue, I'll turn things over to you.
Well, thanks, Mickey. As Mickey said, I'm with the City of Iowa City. I've been here 25 years, well, almost 25 years. And although my responsibilities and assignments have changed over the years from department to topic, I've had municipal infraction responsibility, so to speak, or duty from day one. So I've been dealing with these for quite a few years, and I'm excited to talk to folks about at least the experience I've had here in Iowa City regarding municipal infractions, and do appreciate the leagues as well as IMAA's interest in the topic. Certainly, although I've done quite a few of them, certainly no expert, but we'll take it from here. Um, Municipal infractions are a function, a creature of statute. Section 364.22 of the Iowa Code is everything you need to know, and all you really can know about municipal infractions. And it's a remedy available to cities for a violation of the city code. It's essentially what I think of as a civil ticket. Um, the ordinance must provide that violation is a municipal infraction. So that's the important thing when drafting an ordinance, to include that as a remedy. Um, there are only a couple of limits. The municipality cannot provide the violation as a what we call a municipal infraction, if the violation is a crime more serious than a simple misdemeanor under state law, or a violation of a simple misdemeanor under sort of the criminal code of the state law. But other than that, anything can be a municipal infraction. So we find it a very effective remedy here in Iowa City. And in terms, probably we get issue probably a couple of week. We probably try maybe one a month. Most folks do not contest the violation. But so the typical ones we do here in Iowa City are animal services, typically the dog off leash or the animal not having a license. Housing code, as you can imagine, Iowa City is a huge rental market with all the students, and we have a very vigorous rental code enforcement. So those happen all the time. The nuisance code, the typical ones in cities and towns of accumulation of junk and debris. Occasionally a building code violation, construction without a permit under the building code. Zoning code, here and there, not very often. The typical one we find are the large IV or RV in the driveway. And last but not works, and this happens quite a bit, as a public works violation, construction runoff in violation of the stormwater pollution prevention plan. So those are the typical ones we see um, here in Iowa City. So There's no requirement in 36422 that um, the city has to start with a notice of violation or an opportunity to cure the violation. We generally do that almost in every case because you want compliance. And the notice of violation often gets one compliance. Uh, but I will talk a little bit about the rare exception called an environmental infraction way at the end. And in that situation, there you have to give the defendant an opportunity to cure the violation. Um, and we don't have it in our ordinance, and I would not advise putting it in an ordinance because then you have to jump through that hoop before you can file an infraction. But rather, it makes sense, at least from our standpoint here, to do it as a matter of course to gain compliance. And what we do in the notice of violation is explain the violation, how are you violating the city code, giving them generally 10 days to correct it, and then providing contact information, be it an animal services officer or someone in the building or housing department, so they can contact somebody to work through the compliance. The form itself is set forth in by statute, and it must include a variety of uh, pieces of information. The name and the address of the defendant, uh, the description of the infraction attested to, a violation of section such and such of the code, and a signature is required because it needs to be attested. So that's an important uh, practical reminder, pointer. The location and the time of the infraction, such and such address, such and such time. The civil penalty, I'll talk about a little bit about that, or the alternative relief to be sought, but usually the civil penalty is a dollar amount and the relief sought, clean up the yard, get a rental permit, et cetera, et cetera. Um, how the That's kind of an odd thing. The manner, location, and time in which the penalty may be paid. It's through the court system, but it is a requirement to be found on the form. Where and when you must appear. And we'll talk a little bit about that, how we do it in Johnson County. The penalty for failing to appear, default judgment. And we'll talk a little bit about that too, if you want to put it on the list pendants in a little bit. So here is the form that we use. Um, so again, the docket number, of course, the name of the defendant and the address. There's an opportunity to show when and where the violation occurred, what section of the code, a little narrative. Again, there's a diseased tree, there's no rental permit, there are junk and debris in the backyard or whatever the issue is, and how to correct it, cut down the tree, get a rental permit, clean up the yard, and so on and so forth. In Iowa City or in Johnson County, we use an initial appearance, similar to a criminal ticket, where one has to appear usually 3 to 4 weeks out to ask for a hearing or to plead guilty, so to speak. I know other counties actually use it, require an answer to be filed, but in any event, whatever your county uses, you have to explain that on the form. And then failure to appear may result in judgment, including the civil penalty. And again, the employee's name, and again, has to be signed because it has to be attested to. And then we include, it didn't print off on the same page there, sorry about that. But with animal services, for example, they have just a packet of citations when they're out and about in their trucks, and they can have the defendant sign it. It saves court costs. And certainly other employees use it too, but primarily animal services because they're out and about when the dog is off leash and so on and so forth, and they get the dog back to the owner and the owner signs for it. In terms of who may issue a citation, essentially anybody in the city that's authorized to enforce the code. We've never had an issue with that. Public Works employees sign it, rental inspectors, building inspectors, and animal services officers are the typical ones that do that. So service, service I've always found is a little bit unusual in the sense that you can do it by certified mail. We generally do that with rental properties where you have the LLC being the owner, you serve the registered owner, or the registered agent. But with others, we generally will have the sheriff serve personally unless it's a business entity. Occasionally, we have to publish if we can't find the owner. But so the rules of civil procedure, but you can serve by certified mail, which is a little bit different than small claims or typical of small claims. Then each day is a violation, which is also interesting. So if you don't have a rental permit, for example, you could issue a citation every day until the person gets the rental permit. We don't do that. We've done it a couple of times where maybe every week we've issued a citation to get someone to act, or every other week. But the code does provide that every day is a separate violation. So certainly could do that. I'm guessing the magistrate may raise his or her eyes with that, but it's possible. In terms of the list pendants, this was an amendment to the code a few years ago where you can place the municipal infraction matter on list pendants if you jump through these hoops, which is the same hoops you have for putting any other matter on the list pendants. So what you will do is you just need to attach the legal description to the municipal infraction. Ordinarily, it's just 123 Main Street, but you would have, lot 2 of such and such subdivision attached to the municipal infraction. And then you have to let the clerk of court know to make sure it gets indexed. There's an additional fee. I can't remember what the list pendants fee is, but there's a for that. And then let the county treasurer know. So we've done this once or twice where we are aware of the property is being sold, and we want to make sure that we get our costs for what we've had to take down the tree or to clean up the property. So that's generally when we think the property is. We don't do it routinely because of the extra cost involved. We haven't found it necessary, but it is something that's available to you, but it's just the general list pendants process. So the remedies, this is what makes it all worthwhile and effective. The code says these are the remedies available to you. A civil penalty can be imposed that, it's limited by amount, and I'll talk a little bit about that in a minute, but it's a dollar figure. The magistrate can defer that or suspend it, and occasionally the magistrate will do here if you get your rental permit within, or you get your dog licensed within 2 weeks or a month, then the civil penalty will not be imposed. You can order the defendant to abate or cease the violation, clean up the yard, get a rental permit, which is really nice. But primarily it's 4, which is the real helpful one in terms of junk and debris or a diseased tree, because you can authorize the city to actually take that action. And 5, importantly, get the costs, either by having a personal judgment or collecting it via the special assessment process, which we have to do on occasion. That's a little bit later here on the slide. Kind of go through that process about how we do that. But so those are the remedies. A civil penalty, an order to clean up or to cure, and allowing the city to do it and put the cost back on the offender. Next up, default judgments. If the person here in Johnson County doesn't appear for the initial appearance, a default judgment is entered. I am assuming in other counties where they have an answer required, if you don't answer, a default judgment is entered. And then here is the civil penalties. The civil penalties are limited by statute, $750 for first violation and 1,000 for second or subsequent. And much like the criminal cases, you have to have the judgment entered before it becomes a second violation. It's just not a second time one accuses the offender of violating it, but you have to have a finding of a violation to bump it up to the second or subsequent. And again, the ordinance, your code must set forth the amount of violations you have for your for municipal infractions. And here in Iowa City, we almost everything except with rare exception are either one or the other. One is $100 for the first violation, 250 for the second, and 500 for third or subsequent, or 250, 500, and 750. And I know some communities, I mean, everything is 750 or 1,000, but we've not ramped it up that high. The money, the civil penalty is remitted back to the municipality. So our clerk of court does that monthly. And the court is not, it's a may. So I think the court sometimes think that they have to, but they don't. As a matter of routine here in Johnson County, almost always the the magistrate orders a civil penalty. So the important thing is your ordinance or your city code must provide for the amount of the civil penalty. So in terms of procedure, it's a small claims procedure. The filing fee is the same, it's $95. Again, as I had mentioned earlier, the form that we use in Iowa City is an initial appearance where they can admit or deny the violation, and then a hearing is set in front of the magistrate. You can also file a what quote unquote not guilty. I mean, it's not a crime, but that's a denial of the violation. And a hearing is set. Other communities, as I mentioned earlier, do require an answer to be filed within 20 days. In terms of mediation, here in Johnson County, we have mandatory mediation for all small claims, but the magistrates do not require mediation for citations because they consider them quasi-criminal in nature. One of the interesting things or the unique things about municipal infractions is the burden of proof. It's not preponderance, but clear, satisfactory, and convincing. And we had a district associate judge. At times we've tried these cases in front of the DAJs, but in the last 10 years or so, it's just exclusively the magistrates. But the one DAJ, we always knew you're going to lose because she would say, well, as a reminder that the burden of proof is by clear, satisfactory, and convincing. And that was a kiss of death. She was going to find that we hadn't proved the case. But a little heightened burden. Again, no jury trial because it's a small claim. Next, the jurisdictional amounts, or what I call the amounts in controversy. Those are probably they're not accurate, but I use them to get the point across. Is that if you file a municipal infraction and if the abatement cost exceeds what you think or exceeds the amount that a magistrate can hear, which is $6,500, then you're going to have two hearings in essence. We've had this a couple of times where the fix is quite expensive. That doesn't happen very often, but occasionally it does. And so in that situation, the magistrate hears what I call the liability phase. Did the defendant violate the city code? And if that's the case, then the magistrate does not deal with the abatement or the cure of the violation. That goes up to district court, just on the abatement issue. It's kind of an odd thing, but it is. Similarly, if it's between $6,500 and $10,000, the DAJ can hear it, the abatement matter, but otherwise it goes all the way up to the district court. So the way we've done that is we just tell the magistrate up front that we are going to be requesting an abatement of the violation, and we estimate that violation will be $7,000 or $12,000 or over $10,000, whatever the case may be. So the magistrate ahead of time knows that all the decision that he or she needs to make at this stage is whether or not the code has been violated. And then we just make sure that the clerk is aware that should the magistrate rule in favor of the city on the quote unquote liability stage, that it gets set in front of a district court in short order to determine the whether or not the defendant is going to be ordered to cure the violation. And we certainly have had that happen where the magistrate has, or the district court has said yes, and where the district court has said no. Now, we had a case where it was in a historic district, and the landlord who had bought the property, as often happens here in Johnson County, for the child to go through school and to have the children live, or friends of the children live with them, and they wanted to take the garage down from day one, and historic preservation said no, they couldn't. You had to, because it couldn't be demoed, and so on and so forth. And one time over the weekend, they took it down, and we filed a municipal infraction, and the owners actually cried on the stand saying, oh, it was going to fall over and it was going to hurt their child, and they just had to do it over the weekend, which of course, which was a bunch of hullabaloo. But the cure was to rebuild the garage, which was a big ask. And of course, the district court said no. So they had to pay a small fine, but they got away with it. On the other hand, we had another situation where the fix was about $15,000, and it was a situation where we had a waste management company storing legally storing their dumpsters near a mobile home park, but it was sort of uphill, and the stuff in the mobile and the dumpsters went downhill, sometimes into the mobile home court. We tried to get the company to build a fence, and they wouldn't, and they wouldn't, and they wouldn't. And the judge said, no, you have to build a fence. They didn't build the fence. The city built the fence. And we got our money, our 15 or $16,000 reimbursed to us. So, but it's when they get expensive, one, you're taking a risk that you won't get reimbursed, and you're taking a risk that the magistrate or the district court judge, of course, will not rule in your favor. But okay. I want to talk a little bit about the process for curing the violation, which I think to be the best thing about municipal infractions is the city has the ability to do that. And typically what we do is, or the situations where it happens is when there's junk and debris in the yard, or where there is a diseased tree. Because other violations, we can't do the rental permit, we can't get that for somebody. But if the violation can be cured by the city and the defendant doesn't do it, then the city's able to do it. So let's kind of walk through that a little bit. So what I put in here is just a typical order that you see in Johnson County, where here it was an initial appearance, the defendant failed to appear. And issued the civil penalty of the $250, the court costs of $95 plus service fees. I ordered them to pay, looks like within a month, the 30 days. And then it's the additional relief where the defendant is ordered to cease the violation. Here we had camper parking on the grass. And if the defendant fails to do, the city is authorized to do that. And so that's typically what you have, is just this generic order. You, defendant, cure the violation. In the event that the defendant fails to do that, the city is allowed to do that. So if the defendant does fail, and if we can cure it, we'll file an application for the relief, and I'll show you how, give you a form order and a form application on the next page. And we do that. We do that even though the order has said we can do that. I think it's important to protect from liability from an allegation of a search and seizure, and to protect the contractor, because if we will hire a contractor to clean up the property, for example, or to take down the tree. And I think it's important if you're having a third party go onto somebody else's property, you're doing so specifically under a court order that says, yes, you can go onto the property at 123 Main Street, and yes, you can take down the tree. Uh, so if the property is well, I'll go down and then come back. So I'll just show you what we do in that situation. So what I'll do is I will file, let's say on such and such date, the court has ordered the defendant to, or found the defendant in violation of the city code, and order also authorized the city to cure the violation if the defendant did not do so. And three, that the defendant didn't do it, and the city would like to contract with a private company to remove the junk and salvage material, tires, and cardboard boxes. In order to do so, and to ensure that the plaintiff's agent is authorized to enter the property, we make this application. The prayer for relief is asking for an order allowing plaintiff and its agent to enter the exterior of such and such street and to cure the violation and to assess those costs. We routinely do these. I've never had one denied. And by routinely, I'm saying probably once a month. And then I submit just a form order and says it should be granted for the reasons stated. Then the beef of the order, it's ordered that plaintiff and plaintiff's agent, again, I think that's important because we almost always use a contractor to remove the debris or remove the tree, and that they're authorized to enter the exterior of the property at such and such street or in Iowa City for the sole purpose of abating the violation by doing whatever it is, removing, in this case, the junk, the salvage materials, the tires and cardboard boxes. And then the city is further authorized to dispose of it and assess the costs of abatement against the property at such and such street in the same manner as a property tax, which is talk a little bit about how we do that. But that's the important thing is you get your costs reimbursed, which is the important thing because cleaning up the debris often runs $300-400. Certainly taking down the tree is a couple $3,000 usually. And so kind of going back, if it's a rental property, what will happen after this is we will invoice the owner for the cleanup costs or the cost to remove the tree. And if the owner doesn't pay it, we'll invoice them again. We'll usually do that 3 months in a row. And if they don't, then we go through the abatement or the assessment process, just as one would do with special assessments. We don't do special assessments in Iowa City, and some communities I know do for public improvements, but it's the same process. And so what will happen is here in Iowa City, about 4 times a year, there's a list of invoices that haven't been paid, and we put a schedule together and file the schedule that the finance department puts together. We file it with the clerk of court or the city clerk, and then we put a resolution on the city council agenda asking that these properties be assessed for failing to pay cleanup costs, the tree removal, whatever it is, of X dollars. We let the owners of the property know that it's going to be on the agenda, and they have the opportunity to contest it. And then the resolution appears on the council agenda, and council approves the resolution, and then it gets forwarded to the county treasurer, and it gets added to the taxes and get reimbursed that way. In terms of process, what happens if an owner writes to city council or shows up at the city council meeting and saying, gosh, I shouldn't be assessed for any reason. What we do then is just remove that property from the resolution that's assessing properties that evening at the council meeting and put it on the next council meeting and invite the owner back then to have an opportunity to tell council specifically why. And then we will have city staff there, usually with copies of the invoice and photos, et cetera, et cetera. And so there's not really a hearing, but an opportunity for the property owner to talk to city council and explain why the property should not be assessed. but it works quite smoothly. Again, we generally do it 3 to 4 times a year, along with the other costs such as people who've failed to pay their mowing bill or snow removal bill or sidewalk repair bill. But we always have a handful of property owners who have not reimbursed us for cleaning up their yard or removing a tree. And so that's what we do with rental properties. If the abatement costs are large, such as a tree removal, and it's owner occupied, we often do not go through the assessment process because we don't want a property to be sold at tax sale because all of a sudden the owner's tax bill has gone up by $3,000 to remove a massive tree. In that situation, what we'll do is I'll just file an application with the court and ask for an in rem judgment. We attach an invoice explaining to the court what we've done, and we ask for judgment for $3,000 or whatever the invoice is to be entered against the property, and we'll get reimbursed when the property gets sold. So we do treat rental properties and owner-occupied properties a little bit different if the abatement costs are quite high. So I said that, as I mentioned, routinely what we do with junk and debris, but we've often done it to board up a vacant house. We've asked for authority to go up and literally put some plywood over windows and a door. We built the fence, and that was an example I mentioned earlier. And we also, to repair the right-of-way, what we had was a large contractor, was again a waste management or a waste removal company, and they would cut the corner and they just were tearing up this right of way again and again and again. Of course, they weren't the adjacent property owners, so they were innocent. We couldn't hold them responsible. So we issued a municipal infraction for damaging our right of way against the waste hauler. And then we fixed it. Then we repaired our right of way, and we had the court order that they reimburse us I don't know, it was a couple $1,000s, and they actually did do it promptly. I was a little bit surprised there. I thought we'd have to go garnish or something like that, but they promptly did it. So it really works. I should say quite slick here in Johnson County, and maybe it's just because it's so common. The magistrates hear them time and time again. That it's a smooth process where we've had very, very, very few hiccups at all. Again, there's the application to cure and the order. Again, primarily protecting the contractor, but also city staff. A couple other matters. Parties have the right to appeal, and appeals are heard by the district court, same as small claims. Occasionally, if it's a legal issue, it'll get briefed. And about, every other year, every third year, we've had a few appeals, but not very many. They tend to be legal issues or a pro se matter. Once the civil penalty and the costs all get paid, and the cost of abatement, etc., you have to file a satisfaction of judgment. A willful violation is specifically provided for contempt of court. Occasionally I've had to do that, not very often. We right now are having problems with a particular landlord, and he offered to go to jail rather than clean up his property a couple of weeks ago. So he says, "Well, can't you just send me to jail, Judge?" And so the judge said, "Well, we just want you to either vacate the properties or get a rental permit." So that's still ongoing. We'll talk a little bit about the tenant versus the landlord. Of course, the citation is against the person who's violated the city ordinance. And here in Iowa City, we take the position that the landlord is responsible for the property, even if it's the tenant who's caused the violation, such as the accumulation of junk and debris on a single family house that's rented. And we had a landlord appeal it a few years ago, and this was a situation where the tenant was continuing to park on the grass. And the landlord said, "Well, how can I control my tenant? They park where they want to. I can't be there 24 hours a day, telling them not to park, and so on and so forth." And they appealed it, and the district court said, no, you are responsible, which was the position we took, for maintaining your property. Or you have a rental permit. It's not a right, it's a privilege, and as a matter of course of that privilege, you have to take care of your property. We certainly could have cited the tenant in addition to the landlord, but generally we don't know the tenant's names. Um, and so that makes it difficult. Also, if there's an abatement question, if it is the tenant who's filling up the yard with junk and debris, then we'd have to collect it from the tenant. Whereas with the landlord, of course, or the owner, we can just assess the property and put it on the taxes, and we collect our money. So from a practical standpoint, it makes more sense, at least to us, to pursue the owner of the property rather than the tenant. A few times we have pursued the tenant, don't get me wrong, but 99% of the time we just pursue the landlord. And the landlord can always pursue the tenant to be reimbursed. That's our position. Um, okay. Environmental infractions. These are very, very unique. We did one right when I started. I'm not even sure if I filed it. I think perhaps somebody else filed it because it's quite complicated and it's very limited. As you can see, you can classify a municipal infraction as an environmental infraction, um, but it's limited. If it's a violation of something within the jurisdiction of the DNR or the Animal Agricultural Compliance Act, whatever that is, then the discharge of the airborne residue from grain created by handling or drying or storing of grain cannot be subject to the ordinance um, unless the person is engaged in industrial production or manufacturing. I think the idea is to exclude smaller farming operations and so on and so forth. And then, even then, the discharge of the airborne residue shall not be subject to an ordinance if the discharge occurs in the wintertime from September to January 15. It's punishable by a civil penalty of not more than $1,000 for each occurrence. So that's different because the regular uh, municipal infraction, again, the first violation is $750, but the environmental infraction is automatically at $1,000. Then you have a few more hoops that the violation is solely from the person conducting an initial startup or cleaning. They're excluded. If the person notifies the city within 24 hours of the time of the violation, they cannot get a citation. And if it did not exist for more than 8 hours. So again, fairly limited. And last, importantly, the city shall not enforce this environmental infraction unless the city offers to participate in informal negotiations with the person. And so that is a little bit like the notice to cure, which I was talking about right at the beginning, is that the 36422 does not require, except in this situation, that the city give the owner an opportunity or the city give the owner or the violator an opportunity to cure the violation before issuing the citation. Again, in Iowa City, we almost always give out a notice of violation to try to get compliance, but the statute does not require it except in a situation of a municipal infraction for an environmental violation. So in that situation, you've got to meet with the offender ahead of time and try to work it out. So quite frankly, I don't know why environmental infractions were added to the code at some point in time, but obviously there were some issues somewhere that some legislatures found should be important, but it's extremely limited. And I'm afraid I had one experience and we met. I remember meeting with the lawyer and her client many years ago, and it got resolved, and we've never even looked at that code provision again. And certainly, if anybody else says on the call, I certainly would be interested in your experience, but from the city's experience, no. Case law. There are a handful of cases if you look and to see in the annotations, but almost all of them have to do with recent challenges based on due process and preemption to automatic traffic enforcement ordinances. Um, and So as I said earlier, that 364.22 is a creature of statute. And so there's really essentially no case law to guide one or to guide a magistrate. It's really all in the statute and I think local practice. And again, I'm familiar with what we do in Johnson County, but I would guess from county to county, certainly the practice varies depending on the magistrate or the district associate judge who's ever hearing these cases. But it's really just it's a matter of statute, very little case law, except for one case. And of course, here it came out of Iowa City, not surprising. And it had to do with a nuisance violation. And the argument was, well, you can only have a municipal infraction if it's not, if you cannot, if the crime, if it's a crime that's greater than a simple misdemeanor. And in this situation, the Supreme Court ruled, well, it's only in certain circumstances was it an aggravated misdemeanor and not in all instances. And so that was okay to define or to have a nuisance violation that even though in some circumstances may be an aggravated misdemeanor under state code, as long as it's not in every situation an aggravated misdemeanor in state code, it was okay for the city to have such an ordinance. But really, that's the only one, and it's pretty limited. So there's a question here. Are you aware of any legal authority regarding granting injunctive relief? No, and we've done that. We've had court orders to vacate, let's say, a rental permit or a rental house by the landlord. And of course, what do? You can't really board it up, or you can't have a police officer or a rental inspector just stand at the door and say, tenant, you cannot enter. But what happens is then we will go with a contempt. We've done that. And the magistrate, of course, is furious that the landlord disobeyed the court order. But usually we'll do that because almost all rental permits or rental leases either end in June 1 here in Iowa City or August 1, just with the turnover of students. And so we will often say as of June 1, it's the end of the school year, the tenants must be gone and ask for a court order to that effect, or the end of December at the end of the fall semester. And the magistrates will generally always follow the request of the city. It's only been a couple of situations where it's been a safety matter, a more health and more serious safety matter that we've asked for an immediate relief and an order that immediately that the units be vacated. But you got to kind of keep in mind that the tenants are affected by this, and that's generally why in those situations we'll do it at the end of December or June 1, and the magistrates generally. I've never had a magistrate not do that, and we've had to do a couple of contempts where they haven't done it, and they've been read the riot act, needless to say, and in part because it's a typical landlord that the magistrate probably has seen in other contexts. So no, we've not had any challenges to in essence the injunctive relief that's offered by a municipal infraction.
Hey, Sue, I got another question just
Yeah.
came in. I'll read it to you here. It's related to this service by certified mail. If the property owner does not pick up the mail, do you undertake efforts to personally serve and or publish? Or have you met the requirement because you sent via certified mail despite their refusal to pick up and I'm sure like sign their name and do all the things you're supposed to do when you get certified mail?
Right. That's why we limit usually certified mail to an LLC where there's a registered agent, which tends to be an attorney or somebody like that who will sign. But if we don't get it signed, the registered mail signed, yes, then we will go with personal service. And similarly, if we can't, then we will publish notice. Yes. Um, the typical legal challenges we've faced usually are kind of a void for vagueness. The classic, how was I supposed to know I wasn't supposed to do that? And in Iowa, both under the U.S. and Iowa constitutions, the court has ruled that the defendant bears the burden to show that the ordinance is unconstitutional. It's presumed to be constitutional and given any reasonable construction to uphold it. Um, and the court goes on to say that in vagueness challenges, we've emphasized three things. Can't be so vague that the person of ordinary understanding would not know the conduct is prohibited. Um, might not can't be so vague to encourage arbitrary or discriminatory enforcement, or sweep so broadly that it impacts protected speech. We lost a case about this recently, and it had to do with a patio. Now, one would think everybody knows what a patio is, but the court found that, and I don't disagree with the court, found that our ordinance was vague. And what the owner did, and it was near Kinnick Stadium, the football stadium, is paved the whole backyard and for parking on game days, which we allow on game days, and said it was a patio. And we did not define patio to say, it's, you know, can't be more than 50% of the footprint of your house or can't be any greater than X by X feet. And so the magistrate found the definition in our ordinance to be vague because there was no dimensional or other requirement. And so paving the whole backyard was allowed. And we didn't appeal it. We just amended the code to define patio. Um, so so really, it's generally kind of on notice. There are county infractions. If any of you are representing counties, that identical except for a couple of provisions. One is there's no lis pendens in the county. So you don't have that provision in the county provision in 331, 301. And there's no environmental infraction. Again, probably not surprising since there's more kind of debris in the air that's designed to do there. Afraid I've gotten kind of through this a little bit quicker than I thought. Are there other questions or concerns? I think the last thing I had talked about was my favorite case, and was a poor law student that we had. We thought, well, gosh, this would be a great case for the law student. And a couple of the neighbors had complained about a cat being off the leash all the time, and getting into their flowers, getting into the birds and feeder, and so on and so forth. And so Animal Services issued the owner a cat off leash. And so the poor law student was trying the case, and oh, sorry about that, and was called the got put on the case. Yes, the cat's in there, blah 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 blah. And so then the owner of the cat, or the defendant, I should say, has these pictures of six cats and is beginning to show the neighbor these pictures of the cats, and I can see what's going to happen. Of course, the poor law student doesn't quite realize what's going to happen. The magistrate is almost bursting out laughing because she knows what's going to happen, and shows these pictures of these six cats and says, "Well, which of these cats is my cat? And which of these cats was off leash on this day?" And of course, the poor witness could not identify the cat and lost the case. And the poor law student, he was just beside himself. He didn't say a word all the way back, walked back from the courthouse, and probably to this day, he's not admitted that he lost the cat at large case. But I told him it wasn't his fault. I never expected that to happen and would have prepared him for that. But like the cat got free. But I think it solved the problem. We never had the issue again. But it was kind of a funny case. So I'm sorry if I went through things too quickly or didn't explain something. I'm more than happy to go back and talk about anything or provide any other kind of practical pointer to anybody.
No, not at all. I don't have a question about the cat story, even though that was very amusing. I did have one that's come up a lot actually in my work here at the League of Cities, which is this is especially for smaller communities. Earlier you mentioned like it can be any city official that goes out, does enforcement. And so like a larger city like Iowa City, I'm sure you have different staff who can handle this. So the question I have though is for any city, how do you ensure that whoever is authorized to do code enforcement or issue infractions and all the rest of it from an attorney's perspective, like how do you ensure that they're doing that correctly, that they um, know what they're doing and they don't jeopardize the city's position to pursue enforcement? Do you guys do like training? Do you work with those folks so they know like what's a violation, what's not, or how to, make sure that again, make sure they're doing the right thing?
Yeah, I mean, with multiple staff, even when you have a new person come in, there's usually somebody there with more experience who's done this, and so that helps. They'll come and ask, "Hey, we think we want to issue a citation to so and so for this reason. Does it fit within the code?" We approve every citation before it gets filed, and so if it's not a rental permit, if it's anything unusual, I'll kind of look and go, "Gosh, what's this all about?" I'll reach out to the person and ask what it's about, and so we try kind of check it that way because although most of them are fairly routine, again, lack of a rental permit or junk and debris or the dog without a license, there are a few unusual things, and that's usually what I'll do is just reach out to the person. But a lot of times staff will ask as well, because if it's something new, they think it should be fall under such and such code, or this shouldn't be correct, or this shouldn't be right, or we should do something about it. And we'll try to explore some options that way. But yeah, experienced staff cuts down on the questions I ever have to deal with. That's for sure. And just in a bigger community too. And something that we've been doing. It's just such a routine thing for the departments.
If anyone has questions, feel free to unmute yourself even or use that Q&A.
Yeah,
Got
there
a
was
little bit
something
of time.
from
Oh, go
one
ahead.
up
Yeah.
from maybe from Whitfield and Eddie, but I didn't see it. Kind of went away.
I don't have any in my chat, but it might have gone directly
Uh,
to you. Um,
I'm not seeing it now.
okay.
I don't know. Let's see if I pop it up. Um, let's see. Junk debris. Oh yeah. Is it the experience of the city attorney or those on the call that magistrates routinely limit the covered on the first citation to 750? So again, in our code, we provide that a violation of these ordinances, the first violation is 250, the next one 500, and next one 750, or 100, 250, and 500. So we don't have anything that bounces except for loud parties, not surprising, and over occupancy of a rental permit that are at 750, and the magistrates don't have any problem issuing the 750 to either of those. So I don't know if other communities who set their bar higher, if they if the local magistrate does not like that and either suspends it or doesn't assess it. I not had that issue here, so.
Another question for you, which is what steps can you take to investigate the condition of a building before issuing a citation?
Right. So the inside, the interior, we've actually got search warrants. We just go and get not an administrative search warrant, but a court-ordered search warrant. We have an affidavit by someone. It could be somebody who said they were in the building, an electrician or a plumber who was in there, or a neighbor or somebody, again, whoever you can find to be your affiant. And to go over, then we'll get a court order and allowing um, usually the fire department or sometimes an inspector to go in and authorize that the police department can break down the door to do it. We've had to do that a couple times. We've been situations where we've been concerned where the house is vacant, but the utilities are still on, in particular the gas, electricity, and a neighbor has seen maybe water going through or something like that, where we've gone in for a health or safety. But yeah, we'll go get a search warrant. you.
I have one more for you from myself
Sure.
again, while we have you, and that is the Liz Pendens list, because that's still, I think, somewhat unknown among folks we work with, especially city staff, not attorneys, but city staff. And so, could you just describe a little bit more on how that works when you have a property that you want to issue a citation or infraction, and that what's the power, I suppose, of the Liz Pendens list? Why it's important for cities to use that in certain circumstances?
Sure. We found it where we going to or just have cured a or going to cure a violation. We know we're probably going to have to do that, take down a tree or clean up a yard, but we also know the property is for sale. And we want to make sure that before the sale, if we're going to cure it before the sale closes, we want the to be reimbursed as part of the sale. So that's usually why we've done it, is get it on the list pendants for that reason, or something else is, to use a legal term, fishy going on. We'll put it on the list pendants just in case we're concerned about the transfer of the property. Also, if one is in foreclosure, if we know we're going to have, it's going to get sold at tax sale coming up, we want to make sure it gets on the list pendant so we get, and we can't get it assessed quickly enough. Um, um, those would be the reasons. It's just primarily to assure that we can be reimbursed. Because if it's just your basic violation and it gets sold, well, unfortunately, we'll go after the new owner, but it's really the recoupment of costs or the abatement costs.
Right. And does the existing owner have to settle that before they sell their property?
Yeah, it's
Okay.
a title objection, and
Okay.
that's why the abstractor will pick it up. Otherwise, they won't pick up a municipal infraction that's filed. So
Okay.
you deal with the slam. Yeah.
Got it.
I have a single
We had another
tool
question
that I
come in
want
here, and
is
I know
fixing that I used to have,
oh,
so
I'm
I
gonna
consider that.
mute Sarah. There we go. Sorry. One more question here, and that is, are you aware of legal authority penalizing a city for not seeking a post-judgment order to enter onto property to abate an infraction itself when the right to enter and abate is stated in the underlying judgment?
No, right, I don't.
Yeah, it's an interesting question.
Yeah, it is. It
Wonder,
is.
wonder what the background there is, but yeah, interesting nonetheless. Okay, I think that answers all the questions we received. So thank you once again to Sue for sharing your time and wisdom. We did record this, so again, for the group, I will get this recording transferred over to a video as quick as possible and email all the registrants with that, along with the handout from Sue. And so again, hopefully, as well as the CLE activity number. So hopefully even later today, but maybe tomorrow before I get that post-event email out. So again, thank you, Sue. We really appreciate your time. And thanks to all the attendees for joining us this afternoon. Have a great rest of your day.
Thank you.
Thank you.